Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with a battery with a restraining order. Let's see here. One night my neighbor began insulting me because I parked in front of his house. Common issue. I came out to talk to him. Then he attacked me, and I defended myself. Then the police came and arrested me for a restraining order violation. I guess my neighbor ended up placing a restraining order upon me that I was not aware of. Well, if you're not aware of the restraining order, then that would be a defense in and of itself. If you were in fact aware of it, there could be additional problems. Now, generally speaking, when there is a restraining order against you, you're supposed to keep 100 feet away from your neighbor, and you're not supposed to have any contact with him. When he came out and started yelling at you and insulting you, you probably should have just ignored it, because communicating with him would be a violation of that order. And by the way, any violation of a restraining order would be a criminal case, would be a violation of California Penal Code Section 273.6, which carries up to 1 year in the county jail. So be very, very careful regarding restraining orders. You do not want to violate those. Now, in terms of the battery, let's say your neighbor attacked you physically and you hit him back. That's perfectly legal as long as what you were doing was defending yourself from suffering additional injury or harm. If, however, let's say your neighbor hit you and then he ran off, you do not have the right to chase him, grab him, and punch him. No. At that point, you would both be charged with a battery, which would be a violation of Penal Code Section 242 here in the state of California. This carries up to 6 months in the county jail. Remember that the state of California is not a stand-your-ground state, and whenever possible, you need to run if there is danger. Only when you have no choice do you use physical force, but you can only use the minimal force necessary to avoid for you suffering additional punishment or additional harm. If the harm is over, if the harm is gone because he ran off after spitting on you or after punching you, you can't chase him. You have to call the police and say, yeah, my neighbor hit me. That's what you're supposed to do. I know a lot of people are not going to like that, but that's essentially the bottom line. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, call us now for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who currently has a public defender and wants to change to a private attorney. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.